Guys, welcome back to Prospect Channel TV. Thank you very much for this coming out here. May God bless you all. The legal team of Nnamdi Kaun, the leader of the indigenous people of Biafra, IPOB, Nnamdi Kaun, led by Aloy Ejimakor, has written to the Attorney General of the Federation, AGF, and the Minister of Justice, Abubakar Malami. The legal team of Nnamdi Kaun, the leader of the indigenous people of Biafra, IPOB, Nnamdi Kaun, led by Aloy Ejimakor, has written to the Attorney General of the Federation, AGF, and Minister of Justice, Abubakar Malami. The team is demanding Kaun's unconditionally release in line with the recommendations of the United Nations Working Group on Arbitrary Detention. They reminded Malami of the need to accord Kaun an enforceable right to compensation and other reparations for his continued unlawful detention. The letter was addressed to Malami, and the Minister of Foreign Affairs was signed by Chukwuma Machukwu and Ejimakor. The letter reads partly, "As you must have noted, the opinion demanded the government of the Federal Republic of Nigeria to immediately and unconditionally release our client, Mazi Nnamdi Kaun, and accord him enforceable rights to compensation and other reparations for his continued unlawful detention. The working group requests the source and the government to provide the above-mentioned information within 6 months of the date of transmission of the present opinion. However, the working group reserves the right to take its own action in follow-up to the opinion if new concerns in relation to the case are brought to its attention. Such action will enable the working group to inform the Human Rights Council of progress made in implementing its recommendations, as well as any failure to take action or emphasizes italic, bold, underlining. Your Excellency, we are sending this demand letter to you because we believe that the subject matter falls under the jurisdiction of the Foreign Relations Minister of Nigeria, as it is the duty of the minister to, among other things, ensure that Nigeria complies with our obligations under international law. Thus, in your consideration of the subject matter of the letter, we respectfully invite you to be guided by the following. The working group, which is an integral part of the United Nations Human Rights Council, is a quasi-judiciary body that has the legal mandate of the United Nations to adjudicate human rights petitions brought against member nations, the United Nations. The opinion of the working group is legally binding on Nigeria because it is based primarily on universal human rights standards set by Article 9, 1 of the International Covenant on Civil and Political Rights, 1966. The Universal Declaration of Human Rights, the Universal Declaration of Human Rights, 1948, the body of principles for the protection of all persons under any form of detention or imprisonment, 1988. The Declaration of the Protection of All Persons from Enforced Disappearance, 1992, the Principles on the Effective Prevention and Investigation of Extra-Legal, Arbitrary, and Summary Executions, 1989, Earth Watch Nigeria is a signatory. Some of the above human rights instruments were mentioned in the opinion as having guided the working group in reaching its decision. To be sure, ratification is a means by which a nation renders itself subject to the international laws and treaties, and by virtue of Section 12 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and decisions by the Supreme Court of Nigeria. Ratification makes Nigerians subject to the board by whatever treaties, principles, protocols, etc. that it ratified and domesticated. Thus, Nigeria's domestication of Article 6 of the African Charter on Human and People's Rights, which includes Article 6 that guarantees the rights against unlawful detention. This article is as well very similar to Article 9, one of the International Covenant on Civil and Political Rights. This made Nigeria bound by it, and in extension bound by the opinion of the working group, which it was found on. Furthermore, the International Court of Justice, in its dictum in the hostages in Tehran case, ICJ report 1980 p. 42, parent 91 head, wrongfully to deprive human beings of their freedom and to subject them to physical constraint in conditions of hardship is in itself incompatible with the principles of the Charter of the United Nations, as well as with the fundamental principles in the Universal Declaration of Human Rights. It thus follows that, notwithstanding that a state may not have ratified or otherwise adhered to any of the preceding human rights treaties, it is nevertheless bound by other legal sources to ensure a person's right to respect for his or her liberty and security. This Nigeria cannot afford to squander. It is an opportunity to exploit a more reconciliatory path to resolving the Biafra question. In view of all the foregoing, we must respectfully ask you to bring your good office to bear on the government of Nigeria to unconditionally release our client, Nnamdi Kaun, within a reasonable time after the receipt of this letter. Okay, guys, what's your take concerning this? Kindly share your thoughts below the comment section. Thank you very much. Bye for now.